collectively as your honors and make submissions before this bench.
Okay, I'll maintain.
Your honors, this is counsel number one on behalf of the petitioners, and I shall be dealing with the first three issues of the moot proposition. For the convenience of this court, the two appeals as well as the two writ petitions, along with the SLP, have been clubbed together, and the petitioners shall be dealing with the maintainability as well as the facts of each in their own respective and corresponding arguments. With your honor's permission, I shall begin with the arguments now. Starting with the first issue, your honors, which is whether the non-perusal of an incomplete application under Rule 14 of the Biological Diversity Rule 2004 amounts to an order of determination within the meaning of Section 16J of the NGT Act and is hence appealable. Your honors, we shall be answering to the positive, and we shall be answering so based on two legs. Firstly, that the present appeal is maintainable, and secondly, that the rejection of Mr. Aman's form amounts to an order. Starting with the first leg of the argument, Your Honor, Section 22 of the NGT Act states that any person aggrieved by an order, decision, or a specific decision of the tribunal may file an appeal to the Supreme Court. Your Honors, in the present matter, Mr. Aman's application was rejected by the NBA without the prescribed rules being followed. The NBA violated Rule 14, Clause 3 by not consulting upon either a local body or the applicant before rejection. They also further violated Rule 14, Clause 8 and 14, Clause 9 of the biodiversity rules by not providing in writing the reasons of the said rejection to the applicant and not providing the applicant an opportunity of hearing. Your Honors, the petitioner, Mr. Aman, had submitted an additional application for the waiver of fees of 10,000 rupees, which the NBA completely ignored. Your Honors, Mr. Aman then approached the NGT, but the National Green Tribunal also dismissed his appeal on grounds of procedural impropriety. It is submitted, Your Honors, that Mr. Aman, being aggrieved from the decision of the NGT, has the right to approach the Supreme Court within a period of 90 days, as clearly provided under Section 22 of the NGT Act. Therefore, Your Honor, the present appeal is maintainable. Proceeding to the second leg of the argument, Section 16 of the NGT Act describes the appellate jurisdiction of the NGT, and under Clause G, it states that any person being aggrieved by the determination of benefit sharing or order of the NBA has a right to file an appeal in the National Green Tribunal. The Council submits that a comprehensive reading of Rule 14 of the Biodiversity Rules, we understand that once an application under Form 1 has been submitted to the NBA, the only course open to the NBA is to make an order after the assessment of the situation. Your Honors, it is important to note that the implementation of the biodiversity rules is not discretionary upon the whims and fancies of the NBA, as it lays down the standard procedure of operation that is mandatory to be followed. The Council further submits that Black's Law Dictionary defines the term decision as referring to a ministerial or authoritative act. Your Honors, relying on the same, the rejection of the application of the petitioner by the NBA amounts to an authoritative act and is therefore a decision. Your Honors, if you could please refer to para 15 of the moot proposition, it is clearly mentioned that petitioner's application was rejected. Moreover, bringing to your notice in the same paragraph, the word stated emphasizes that the decision was made in writing when read with Section 15 of the Biodiversity Act, read with again with Section 13 Clause A of the Biodiversity Rules. Your Honors, the Council submits that anything in the nature of an order, even though not expressly specifying so, will be deemed to be an order under the Biodiversity Act and is appealable. This also extends to decisions beyond power of the NBA and the State Biodiversity Board under Section 19 and 24 of the Biodiversity Act. To establish the same, the Council would bring the attention of the bench to the case of Leela Sun Breweries Limited versus MP State Biodiversity Board, where a mere notice, Your Honors, although not an express order under Section 24, was deemed to be an order under the Biodiversity Act, and even the tribunal admitted the appeal on such grounds. It is therefore very humbly submitted that the very reading of the facts as mentioned in para 15, the comprehensive reading of Rule 14 of the Biodiversity Rules, and the judgment in the case of Leela Sun Breweries clearly show that the NBA's decision to reject Mr. Aman's application amounts to an order, and it is not a mere dismissal of application, and therefore it is appealable. If Your Honors are satisfied, may the Council proceed with the second issue in hand.
Yeah.
Much obliged, Your Honors. The second issue is whether Rule 14 of the Biological Diversity Rules 2004 is constitutionally valid. Your Honors, we shall be answering to the negative, and we shall be answering so based on three legs. Firstly, that the writ petition filed by Mr. Aman and Spreading Smiles is maintainable. Secondly, the said rule is arbitrary and classifying in nature. And thirdly, that Article 21 of the Constitution of India is violated by the said rule. Starting with the first leg of the argument, Your Honor, in the present case, Mr. Aman and Spreading Smiles have filed a writ petition challenging the constitutional validity of Rule 14 of the Biodiversity Rules on grounds that it is violative of Article 14 as well as 21 of the Indus Constitution. It is further submitted that in the case of DC Wadhwa versus State of Bihar, it was held that any member of the public could challenge any law which is against the rule of law by filing a writ petition. And it is the constitutional duty of the court to adjudicate upon such laws. Your Honor, the petitioners under Article 32 of the Constitution of Indus have the right to approach this court, and therefore the present writ petition is appealable. This brings us to the second leg of the argument, Your Honor. Article 21 of the Constitution of Indus provides that a state shall not deny to any person equality before law or the equal protection of laws within the territory of Indus, and the state is bound to protect every human being from such an equality. Your Honor, the Supreme Court evolved the new doctrine that Article 14 is a guarantee against arbitrariness, where in the case of E.P. Royappa versus State of Tamil Nadu, Justice Bhagwati stated, equality is a dynamic concept with many aspects, and where an act is arbitrary, it is implicit in it that it is unequal both according to political logic and constitutional law, and is therefore violative of Article 14. It is important to note, Your Honor, that this provision extends to even non-citizens. And it is important further to note that Mr. Aman in the case is a non-citizen, which was held in the case of National Human Rights Commission versus State of Arunachal Pradesh, that Article 14 extends to non-citizens as well. Your Honor, the Council submits that the question whether an impugned act is arbitrary or not is ultimately to be answered on the facts and circumstances of a given case. Your Honor, Rule 14 states that a non-citizen but a resident of Indus intending to use biological resources for non-commercial research will have to pay a fee of rupees 10,000 to access the said biological resources. Your Honor, the Council submits that the said fee is not in the nature of quid pro quo, which means a favor or advantage granted in return for something. It is important to understand, Your Honor, that the non-commercial research is done for public good and not for an individual's own benefit. It is submitted that in the present case, Mr. Aman, a non-citizen, wanted to research for the public good of Indus, and for the same, he had to pay a fee of rupees 10,000. To establish that the petitioner wanted to research for the public good, para 7 of the Moot proposition shows that Mr. Aman wanted to develop a cure within Indus, and that he had filed an application for the same under Form 1, which is for non-commercial research. Furthermore, Your Honor.
Just a minute, Council. You mean to say all these fees which is prescribed to just come with the application, that will be separately for the commercial use as well as non-commercial use, and one has to clarify that I'm coming it for the non-commercial use, or it's a set procedure of law or procedure prescribed over there. So what you take it?
Your Honor, the Biodiversity Act is silent on the non-commercial aspect of it. And for the same, Your Honor, we are contending that Mr. Aman was coming here for a non-commercial use of the said biological resources.
Doesn't matter, then what made them to waive the all fees which is prescribed to come with the application? He has come with the incomplete application in turn.
Indeed, Your Honor. But the current situation that we are facing of blood fire in our country, Indus, Your Honor, we need to understand that it is exceptional. And it is also submitted that in the fact sheet it is clearly stated that Mr. Aman did specify an additional application for the waiver of fees. Also, Your Honor, to substantiate on the same, it is stated in the fact sheet, if you could please let me refer, under para 11 and para 12, that Mr. Aman had left his job, and since he has left his job before 7 years of completion of his job, he was also devoid of post-employment benefits.
No, sir. When you put up application, so for the administrative body, those who are going to entertain, you mean to say that they have to take consideration of all the situation, like who is the person applying for that, whether he is a humble background or rich, or with job or without job, or there is a set procedure for everyone who's ever applied for that.
Indeed, Your Lordship, indeed, Your Honor, there is a set procedure under Rule 14 of the Biodiversity Rules. But when reading Rule 14 of Biodiversity Rules, we also understand under Clause 3, the body, the NVA, that is the body concerned, should consult with the local bodies, and also should, before rejection of any application, should specify whether the rejection was made, and also give the chance to the applicant for a chance to be heard, which was completely devoid, Your Honors, in this case.
So you call it rejection or just not entertain even?
Your Honor, it is a rejection. For the same, we can rely on, if you would let me refer the Moot proposition. Uh, it is a rejection, Your Honor, as per para 15 of the Moot proposition. I would like to bring it to your notice. The word stated clearly states that it was rejected, Your Honor.
So you are taking a strict interpretation to that.
Indeed, Your Honor, and this, for the same, we are relying on Section 15 of the Biodiversity Act, which states that any order or a mere decision is supposed to be in writing and should have the seal of the chairperson. Therefore, Your Honor, and relying on the case of Leelas and Breweries as already cited, any mere decision could also be taken into consideration of an order.
Move further.
Much obliged, Your Honor.
Yeah, Counsel, I just had one question. If you take a look at your memorial, which you've submitted, your difficulty in terms of the constitutional validity of Rule 14 seems to be, as you've articulated it in the memorial, I'll read it out for you. The contention being raised is that the procedure for getting access to biological resources and traditional knowledge, which includes accompanying a check or demand draft in favor of the authority, is violative of fundamental rights. So you seem to have a problem with a requirement for an accompanying check or a demand draft. Now, let's take it for a minute that instead of rupees 10,000, they now require you to give a fee of, let's say, not a fee, an amount of, let's say, rupees 50 or rupees 10. Then would your argument still stand that it is unconstitutional?
Indeed, Your Lordship, indeed, Your Honor, what we are concerned about is non-commercial research, particularly in this case, Your Honor. And addressing your question, the council submits that even though a fees of rupees 50 or 100, we need to understand the current situation that we are facing. And it, as per relying on the facts, Your Honor, Mr. Aman's research was the first to have a potential cure to this. The NVA should have consulted under Rule 14, Clause 3 of the biodiversity rules with the local authority as well as the applicant for the same before the said rejection was made.
Right. No, but the question is, you seem to be pitching your case at a very high level that any sort of a requirement to have an amount along with the application would be unconstitutional. Right. So we can't obviously view unconstitutionality from the prism of what is existing at a particular point in time. Right.
Indeed, indeed.
Not a fluid concept. It's something which you have to obviously establish on the, let's say, on a normative basis. So therefore, look at the RTI Act. The RTI Act also requires you to say, given, say, an application with a fee of rupees 10. Right. So therefore, the question is, if we accept your argument, then basically every statute in the country which requires any sort of a amount to be paid for an application to be made would be rendered unconstitutional. So therefore, is that the extent to which you are pitching your case? Or are you pitching your case limited to the fact that the amount of rupees 10,000 mentioned here, on the face of it, is too onerous for somebody who is engaged in non-commercial research work? So what is the point you're making?
Your Honor, the fees that should be charged should be in the nature of quid pro quo, which in the said case is not. Mr. Aman only wanted to take said resources, and it is supposed to be considered how big of an amount of resources of the biological resources would Mr. Aman take for it for merely non-commercial academic purposes, Your Honor. And since the fee is not in the nature of quid pro quo, therefore we are contending that it's violative of Article 21. Also, we shall be establishing in the coming legs that it is there exists no intelligible differential.
All right, please, thank you.
And I have a question. And when you're talking about quid pro quo, are you looking at one-to-one correlation or overall quid pro quo?
Much obliged, Your Honor. We are looking at one-to-one correlation, Your Honor.
And is that the concept behind quid pro quo?
No, the doctrine means that it means that a favor of advantage to be granted in return for something. This is what the doctrine works, and this is the correlation that we are trying to establish.
And any judgment which says that it has to be one-to-one correlation?
Counsel, please ignorance, Your Honor. The counsel is unaware.
Please proceed further.
Indeed, much obliged. Therefore, Your Honor, the fee actually is in the nature of a fine and not in the nature of a quid pro quo or a penalty for doing non-commercial research in the general public interest. Additionally, to further substantiate the same, the council submits that the said rule keeps charging a fee from residents, even though the 171st Law Commission report on Biodiversity Bill itself exempted residents from seeking approval and charging fee from the NBA. Your Honours, relying on the submissions made and the case of Deepak Sibal versus Punjab University, where the Supreme Court dealt with the principle of intelligible differentia, the council submits that intelligible differentia does not exist in the said case, as the said rule clearly doesn't differentiate between commercial and non-commercial research, and even the Biodiversity Act is silent on the same, and therefore Rule 14 Clause 2 is unreasonably classifying in nature. Your Lordship, if such research is restricted, the threefold objectives of the Biodiversity Act are the threefold objectives of Biodiversity Act weakens, which are conservation of biodiversity, sustainable development, and fair and equitable benefit sharing. Your Honours, it is important to note that Article 14 allows reasonable classification and not class legislation, as held in the case of State of West Bengal versus Anwar Ali Sarkar. It is further submitted that the said rule lacks any reasonability and a determining principle, and Your Honour, any rule which shows such characteristics would be deemed arbitrary, as held in the case of Sharma Transport versus Government of Andhra Pradesh. This brings us to the last leg of the argument, Your Honour. It is humbly submitted that the right to life concerns the sanctity of human life, which is the most fundamental of human social values. Your Honours, in the present matter, non-approval of the application submitted by the appellant due to the absence of the said fee resulted in a considerable amount of delay in finding a cure for blood fire. It is further submitted that eventually the NBA did have to resort to Mr. Aman's research to find a cure for this virus. This delay, Your Honours, put the lives of the people of Indus in grave danger and caused immeasurable sufferings to many diagnosed patients as well as their families. Therefore, in consideration of the contentions made, it is humbly submitted that Rule 14 of the Biodiversity Rules, Your Honour, violates Article 21 of the Indus Constitution and is therefore ultra vires the Constitution of Indus. If Your Honours are satisfied with the council, proceed with the last issue.
Yes.
Much obliged, Your Honours. The third issue, which is whether the NBA is a state and whether its decisions are protected as sovereign functions. Starting with the first leg of the argument, Your Honour, where the council would establish that the NBA is a state. To emphasize on the fact that the NBA is a state, we shall be relying on the test of government control as laid down in the case of Ujjambai versus state of Uttar Pradesh. Before starting with the test, Your Honours, it is important to note that the word includes in Article 12 indicates that it is not exhaustive in nature, and the NBA to be ascertained as a state has to come within the purview of other authorities under the said definition. Starting with the test, Your Honour, Section 8 of the Biodiversity Act states that the NBA constitutes of a chairperson, 10 ex officio members, and 5 non-official members. This makes a total of 16 members, Your Honours. And other than the 5 non-official members, it is submitted that rest 11 members are appointed by the central government. It is submitted that Section 26 of the Act states that the NBA receives loans and advances from the central government, which is used for the working and functioning of the NBA under the National Biodiversity Fund, as stated under Section 27 of the Act. As per Section 29, Your Honour, the Controller and Auditor General of India, who, Your Honour, is a government official, will solely be responsible for auditing of the accounts of the NBA. As per Section 27, Your Honours, the expenses such as salaries, allowances, and pension payable of the NBA are to be defrayed out of the Consolidated Fund of Indus. Your Honours, even the official website of the National Biodiversity Authority clearly states that it is an autonomous statutory body under the control of the Government of India. The council further submits that under Section 48 of the Biodiversity Act, the NBA is bound by directions given by the central government, and it even performs advisory functions for both the central as well as the state government under Section 12 of the Biodiversity Rules, Your Honour. Therefore, it can be clearly be seen that the government has deep and pervasive control over the functioning of NBA, which establishes, Your Honour, that the NBA is definitely a state. Your Honours, this brings us to the last leg of the argument, where the council would establish that the decisions of the NBA in the present case would not be protected under good faith. Section 54 of the Biodiversity Act provides protection from legal proceedings to officers of NBA for anything done in good faith. It is submitted the Biodiversity Act does not define the said term, and for that we rely on the IPC, which under Section 52 defines an act to be done in good faith. It is to be carried out with due care and attention. In the case of N. Nagendra Rao and Co. versus State of Andhra Pradesh, the Supreme Court observed that no civilized system can permit an executive to play with the people of its country and claim that it is entitled to act in any manner as it is sovereign. Your Honours, it is very important to establish that the NBA cannot take the defense of good faith when it violates the provisions of the Biodiversity Act, second, when it violates the principles of natural justice, and last, when it violates any fundamental rights enshrined in the Constitution of Indus. In the present case, Your Honor, as you're already aware, Rule 14 Clause 3, 14 Clause 8, 14 Clause 9 of the biodiversity rules were not followed while rejecting the application of the petitioner. Your Honor, this substantiates the fact that the NBA violated the provisions of the Biodiversity Act itself, as well as the principles of natural justice under Audi Alterum Partem, as Mr. Aman, the petitioner, was not given a chance to be heard. And thus, the NBA here cannot seek the defense of good faith. The council further submits that it is saddening that the NBA has failed to appreciate the urgency of the matter, and that was to find a cure for blood fire, which has engulfed our country, Your Honor, to such a state that a strict lockdown has been imposed. The economy is continuously following, and it is so fatal in nature, the blood fire virus, that even this hearing today is happening in an online forum. Therefore, Your Honors, the Council very humbly submits that following the procedure under the biodiversity rules and ABS guidelines is not prima facie subject to the discretion of the NBA. And even if it has to reject an application, the prescribed procedure has to be followed, which was not in the present case. Your Honors, the NBA decisions are not taken in good faith, and hence it is not protected as sovereign functions. That would be all, Your Honors, from my side. It was an honor arguing before you.
Still one question.
Indeed.
You said that about the sovereign function, and you have given exceptions also. So do you think this court want to know that sovereign function is standing today also in any contest?
Indeed, not, Your Honor. In the case of N. Nagendra Rao versus State of Andhra Pradesh, the concept of sovereign immunity was diluted. And in a post-constitutional era, it cannot be relied on.
For all the matters or for certain matter?
The ambit definitely was restricted, Your Honor, in the said case.
As the applicant, Aman has filed an affidavit to the effect that it will not be used for commercial purpose.
Your Honor, the fact that he has filled the application in Form 1, if he would have been given an opportunity under 14 Clause 8 and 14 Clause 9 of the biodiversity rules, he would have stated that he had no intention to commercialize the same. This can be established later.
It can be easily presumed that it would be used for commercial purpose.
Your Honor,
but is any invention of this nature, either he or somebody else would purchase from him and would be used for commercial purpose. So by nature, his attempt is to use a commercial purpose, and could it be presumed that he suppressed that idea?
Your Honor, as clearly stated in the facts, Mr. Aman's acumen is in research and not business. Furthermore, later in the said facts, it is stated that Mr. Aman's
all inventions start from business point of view, or starts in big. Casually, almost all the inventions are casual, but later it was commercially used. So there is nothing wrong in the authority pursuing that it should be specifically stated that it would not be used for commercial purpose, nor it be sold for commercial purpose.
Indeed, Your
Honor.
But
that is a fact. From the facts, it is not clear. Okay, continue.
Just I would like to point out, indeed, Your Honor, you're definitely right, but the same cannot be inferred from the facts. Nowhere it is stated that even though it is not stated that he would not use for commercial purpose. It is not stated the fact that it would be used for commercial purpose. It is left on our discretion, Your Honor, and the fact is silent on the same.
But Counsel, even if it is silent, but you are trying to take benefit of that stating again and again that he is not going to use it for commercial purpose.
Your Honor, Mr. Aman is a very selfless man, and the same can be inferred from the facts, Your Honor. Under Moot Proposition 11 and 12, that even though the economy was sinking, people were losing their jobs, he still left his job to pursue his research to finding a cure for the people of Indus for the blood fire virus, to such an extent that he even left his post-employment benefits, Your Honor.
That he ought to leave, because as per the terms of agreement of the job, he could not work for the 7 years.
He did leave his job on his own discretion, Your Honor, to find a cure for the same.
Okay.
All right.
Okay.
All right. It was an honor, Your Honor.
Your Honors, may it please this court that this co-counsel will be dealing with issues 4, 5, and 6 of the framed issues from the Moot proposition. With Your Honor's permission, may the counsel start off with the 4th issue?
Please.
Much obliged, Your Honors. Issue 4 deals with the question whether the non-disclosure of material facts vitiates the contract between National Biodiversity Authority or NBA and Bhole Developmental Board or BDB. Before contending so, the counsel humbly submits that this petition is maintainable before this honorable court. The appeal for the writ filed by BDB stands transferred to this honorable Supreme Court under Article 139A, Clause 1. Contending violation of constitutional rights and fundamental rights, this petition is maintainable and will be shown so by the counsel in the course of arguments. Your Honors, this contract being governed by the In This Contract Act will be valid only if all the essentials under Section 10 are fulfilled. One of the essentials being free consent by both the contracting parties and consensus ad idem. If the consent of the contracting parties was taken by a false promise, it vitiates the essence of the agreement and thus the contract becomes voidable at the option of the party whose consent was so caused. This false promise can be through active concealment of a material fact and the non-disclosure of the intention to perform the same, which is deemed to be fraud as per Section 17 of In This Contract Act. In the instant case, Mr. Simon approached the tribe and promised them due benefits if the methods to synthesize drugs out of Gemage plant was shared with the committee. It was on this promise of commercial benefits and IPR that the tribe agreed to the contract as per para 25 of the fact sheet, Your Honors. And
just a minute, one question, counsel. You're talking about the material facts and fraud of the agreement, contract, etc. We would like to know what constitute material facts, and particularly in your matter, which facts are being taken as material facts?
Indeed, Your Honor. Your Honor, the non-disclosure of the material fact being contended is the excessive uprooting of Gemage plant and hiding of an active concealment of the fact of due benefits being given to the tribe in interest of non-commercial production of this
all right, they have uprooted a truck of that. So,
indeed, Your Honor.
So what would have been the required quantity? Half truck? No, to make this fact not material fact, what would have been the quantity taken?
Your Honors, there should be pilot basis and a quantity of sampling basis considering the Gemage plant was just one of the ingredients being used for the cure of blood fire. Further on, Your Honor, what the petitioners are being aggrieved of is that due benefits were given to them of a non-commercial production, whereas it was in fact agreed in para 25 of the fact sheet that there will be commercial production of the medicines, which was at a later point of time not done so by NBA, even though they promised the same, which is fraud, Your Honor, as per Section 17 of the In This Contract Act.
So according to you, what fact is concealed?
Your Honor, the fact that NBA never had the intention of commercially producing the medicine, and the second fact being there was excessive uprooting than what was in fact promised or intentioned for.
All right.
Much obliged, Your Honor. Your Honor, without duly informing BDB, NBA relentlessly uprooted the plants and shared dissatisfactory determination of benefits. Since the status quo hasn't changed in the country of in this, that is of a pandemic, since the formation of contract, now they cannot claim this defense of greater public interest and medicine for epidemic. It is evident from their intentions that they never had the intention to make good the contract, which has led to nothing but destruction of the tribe's livelihood and culture. At the end, equivalent benefits were not shared with BDB, which was one of the main objectives of the Biodiversity Act. If the bench turns their attention to the case of Divya Pharmacy versus Union of India, the court relied on purposive interpretation of law, ruling its applicability on contracts as well, and the need for upkeeping of benefit sharing with local communities. Your Honors, another crucial aspect associated is the excessive uprooting of Gemage plant, resulting in the violation of rights of tribe to conserve their culture under Article 29(1) of the Constitution. Article 29(1) guarantees a general protection to any section of citizens having a distinct language, script, or culture of its own, and the right to conserve the same. Your Honor's para 19 of the fact sheet clearly makes it evident that the tribe had their own way of life, culture, and traditions since time immemorial, revolving around this Jemech plant. It was involved in their wedding ceremonies, festivals, and the local hakims and Vaidyas synthesized medicines from it. Clearly, Your Honors, the tribe's lifestyle cannot sustain without the plant, and it is very much within their right to conserve the same. And it forms a part of their fundamental right as well, because in some way it affects their right to livelihood under Article 21 of the Constitution. If Your Honor is satisfied with the fourth issue, may the Council move on to the fifth issue?
Yeah, I just had a query for you. See, Article 29 uses the term culture, right? Now, you might be able to bring in the usage of a particular plant in a particular manner as forming part of culture. But how do you bring within this understanding of culture? Do you have any case law to support your proposition that a plant variety by itself will fall within the meaning of culture under Article 29?
Your Honor, as per first relying on the facts to answer the question, para 19 of the fact sheet states that the plant was an intrinsic part and deep rooted in the culture, considering so that it was involved in it was an essential practice involved in their wedding ceremonies. It was one of the major ingredients of their festivals and religious rituals. Therefore, Your Honor, without the sustenance of this plant, these cultures could not have been continued. Thus, the council contends that yes, in fact, it was deep rooted within their culture and therefore forms a part of their culture.
Now, let's take an example. Let's say this plant is then grown somewhere else in the country. Could you still claim uprooting of culture if this plant could then be imported, say, from some other part of the country?
Your Honor, this plant was in fact an endangered species and enlisted in the red list of IUCN's threatened species. Therefore, on the first hand itself, its source was very limited. Now, with excessive uprooting by NVA, it would have definitely become extinct, Your Honors, if the petitioners would not have raised this contention. Therefore, there is no other source from where the sustenance of this plant could have been carried out. And
Right.
further, much obliged, Your Honor.
Right. Have you seen if this protection is something which is offered under the Recognition of Forest Rights Act 2006? Have you been able to draw a parallel between the protections available under that statute and what you are addressing today?
Your Honor, this right is a general provision and an absolute right for the preservation of minority culture. And the act stated by Your Honor also mentions for the same of the rights giving it back to the tribes. Furthermore, Your Honor, it was upheld in the case of Animal Welfare Board of India versus A. Nagaraj as well, that the tribes who have been strayed from their tribal areas need to be given this right still.
Thank you.
Much obliged, Your Honor. Your Honors, moving on to the fifth issue, which pertains to the question whether NBA is responsible or accountable for harm to an endangered species, which in the present instance is that of Jemech plant. The Council presents two arguments to contend the same. First being, Jemech is a declared endangered species under the IUCN Red List of Threatened Species, and in thus being a state member of IUCN since 1969, has the responsibility to preserve the same. The relevant provisions under Biodiversity Act and rules and guidelines made thereunder cast a duty on NBA to ensure that the objectives of the Act are carried out without rendering such biological resources to peril. Case in point, Section 40 of the Act, read with Rule 16 of Biodiversity Rules, prohibits NBA from giving approval to access endangered species. Moreover, per Rule 14 of Biodiversity Rules, the terms of approval of accessing biological resource include a conservative approach to its utilization. However, in the instant case, Your Honors, truckloads of not only Jemech but other indigenous plants were also uprooted and taken to nearby labs. There was 30 days of relentless uprooting of plants, thereby showing that NBA did anything but follow the prescribed laws. The fact is not privy that Indus is a member of international community that strives to protect the environment, but it was in furtherance of these objectives of the Biodiversity Act that it had the duty upon itself. Moving on to the second argument, Your Honors, the public trust doctrine, as propounded in the case of MC Mehta versus Kamal Nath, states that the state, being a custodian of natural resources, has the duty to preserve the same from overuse and extinction. This protection of environment is needed because it forms an invaluable part of the larger ecosystem, as reiterated in the case of T.N. Godavarman versus Union of India. However, the possibilist approach, Your Honors, of NBA is trying to deny the influence of environmental factors upon the citizens, thereby discarding a plethora of judicial pronouncements, including the ones recently mentioned by the Council. Your Honors, it is pertinent to note that not following the conservative approach towards utilization of GEMH plant may result in its extinction, thereby leading to non-availability of the said biological resource for curing this epidemic itself, prevailing for an uncertain length. Since NBA overlooked this duty, it needs to be made liable to the central government and as a domino effect to the general public. If Your Honor is satisfied with the 50.
Just one question. Council under section 54, they have the privilege or shelter of good faith. So they are doing everything in good faith. When pandemic situation is such, they need to have research in the public interest also. What do you want to say for that?
Indeed, Your Honor. However, NBA owed a good faith obligation towards the tribes as well, Your Honors, under the same Act of Biodiversity Act. Furthermore, constitutional supremacy and the rule of law states that one obligation cannot be cast aside just because there's a special provision created. Your Honors, NBA could have clearly subsidized the medicines produced and given it to the patients. At the same time, giving due benefits to the and taking care of the plant for the sake of the tribes as well. Like
that's what they are trying to do. That's what they are trying to do. They are going to share the profit benefit also. And you know, this as such type of agreement for the development of the area. It is in the interest of general public also. So what objection do you have in that case?
Your Honor's good faith is not an immunity in itself, and it is up to this court to determine it in the base on the basis of facts and circumstances. But it does not keep them merely behind the wheel of law of this protection that they owed a greater duty to the pandemic, whereas at the same time they owed a duty to the tribes as well. They could have, Your Honors, the petitioners in the tribe are not stopping NBA from uprooting these plants. It's merely saying that it should have applied reasonableness and its wisdom such that it, first of all, being an endangered resource, is less in source, and therefore judicial use should have been taken by NBA to uproot it, which it did not.
All right. Council, you mean to say the priority should be to save the plant and the tribe area at the cost of thousands of people who could have been saved with the use of that plant? What should have been the priority?
Your Honor, considering that this plant was just one of the ingredients utilized in the cure for blood fire, truckloads and relentless uprooting was not required, Your Honor. Pilot, survey and sampling basis could have been used to uproot these plants. Furthermore, Your Honor, patients will definitely recover and go about their lifestyle, but the respondents cannot give a roadmap of how the livelihood of tribe can be sustained after the end of the pandemic, Your Honor.
Okay, one more question. Do you mean to say, in case after research it comes that this is the only drug which can save lives of thousands and thousands dying people, then when they comes and government takes trucks and trucks of the plants, then you will be agree to that?
Your Honor,
you want to give sampling now, no? If the sample is approved and approved with the condition that it will save life of thousands of people, so obviously the government will be coming and again taking the same plant. What will be the action of your community?
Agreed, Your Honor, but still the relentless uprooting and excessive uprooting for 30 long days does not justify how one small ingredient, that too for a medicine, which might have been required in small quantities, how does it justify almost extincting this plant, Your Honor, by NBA. Furthermore, Your Honor, consider owing to the pandemic itself, if in case this plant now becomes extinct, there would be no more resource available that would alternate this gem-edge plant, Your Honor. Therefore, we are also contending for the sake of the pandemic itself, Your Honor, that it was relentless uprooting and excessive uprooting.
All right, move further.
Much obliged, Your Honor. Your Honors, moving on to the last issue, which pertains to the question whether Epidemic Diseases Act and the implementation thereof is constitutionally valid. Focusing on its maintainability first, Your Honor, the High Court, as a constitutional court under Article 226, has the authority to decide upon the constitutionality of a legislation. But in the instant petition, it was rejected by the High Court, stating that judges can't be legislators. However, Your Honors, Ramesh never prayed for enactment of a new legislation, but just to check the virus of the Epidemic Diseases Act and the violation of Article 21. The same will be proved so by the Council in the course of arguments. To contend the same, the Council presents 3 arguments. Starting off with the first argument, that implementation of the Act through Delhi Regulations 2020 is arbitrary in application and lacking in legislative competence. It is submitted so since regulations call for imprisonment under 188 of IPC only if the offender fails to pay penalty on the spot. However, Ramesh was arrested without being asked for fine firsthand and wasn't even let know the reason for this arrest. He was brutally beaten up in police custody, for which now he can't even file suit, considering they are provided legal immunity for good faith, which is in clear contravention of Article 300 of the Constitution that allows the state to be sued. Moving on to the second argument, Your Honors, that the Epidemic Diseases Act is archaic since it is filled with ambiguity, excessive delegation, and provides a huge scope for unguided discretion in administrative action. The citizens are now at the peril of the central government as to when it deems fit an epidemic situation is arising, considering there is no definition for this epidemic, and it now depends on the district authorities as to what they consider good faith, since they have not even given an exception of essential services and medical facilities as to when the citizens can step out and just put a blanket curfew. Concluding with the third argument, Your Honor.
Counsel, I want to come in here and I want to have some clarity on the argument. Just let's try and test your argument. You are questioning the power of the central government in declaring a situation as a pandemic. You have to bear in mind that what you are questioning is a constitutional arm of the governance, which has been imparted the duty and the responsibility to run the country in a manner as the Constitution determines. And this is also the elected representative. This is a democratic form of government that we are dealing with. So suppose the central government should not have this power. Who in your wisdom should have this power? It can't be a lacuna that that there is there's a absence of any any kind of regime in place. So what would be your suggestion? This question is only to test your argument.
Yes, much obliged, Your Honor. Your Honor, as per the Disaster Management Act, it calls for an action plan and a national strategy as to when these epidemic situations arise and what steps the state governments can be taken, such that it is not arbitrary and within the legitimate expectation of the citizens. However, Your Honor, the Epidemic Diseases Act being merely only 7 clauses long, that too in qualitative and ambiguous, and having no standard operating procedure as to how the state governments should in fact deal with imposing lockdown and quarantine rules. Now it puts the discretion onto the various district courts as to how they should now interpret and exercise their discretion in considering what is good faith and what are the exceptions under which the citizens are allowed to be stepped out in case of emergency situations like accessing medical facilities. Therefore, Your Honor, there is no...
You are not answering my question. Who do you think should be filling up this lacuna if the government does not do it? Also, kindly bear in mind that when we are talking about reasonableness, arbitrariness, these are competing claims. In a situation of pandemic, it's not like you have choices which are good choices, that you have apple on one hand and orange on one hand. These are choices which are like Hobson's choices, devil on one hand and deep sea on one hand. These difficult choices have to be made in the times of pandemic. Who should be in the driving seat if not the elected government and the constitutional arm of the as prescribed in the constitution?
Your Honor, just two contentions to answer this question. One being, if the act called for a standard operating procedure as to how the government should in fact act upon and what all its powers were, the central government and the state governments themselves would never have acted and legislated such arbitrary regulations such as that of Delhi Regulations 2020, which the act clearly lacks. Furthermore, Your Honors, if this honorable bench now strikes down this law, it being a constitutional court, can pass directions as law for the time being, which was also done by this court in the case of Vishaka versus Union of India.
This court has enough powers to strike down anything that is found to be arbitrary. But counsel, there is a concept of play in the joints. We have to allow sufficient leeway, sufficient play in the joints for the executive to work. You can't have, in a pandemic situation, you can't have a pill of panacea or a one-size-fit-all formula which can be applied in all cases of pandemics. These are dynamic situations, as we are seeing. We can take judicial notice and cognizance of this fact that the situation is extremely dynamic and it is changing by the hour, by the day. So, and of course, the rule of law is in place. If we find it to be arbitrary, then we will strike it down as arbitrary. But the point is that if not the central government, then who? Anyways, thank you, counsel, for helping us understand your point of view. I think your time's up.
If the counsel could have just 15 seconds to make one small submission to that question, Your Honor. Much obliged, Your Honor. Your Honor, there should be at least prescribed grounds on which the government should declare this epidemic situation, and prescribed grounds should be at least laid down in the act as to what the Ministry of Home Affairs should consider as exemptions of essential services, Your Honor, which is not done in this act, Your Honor. That is what the council humbly contends.
Thank you, counsel.
Much obliged, Your Honor. Can the council move on to prayer?
I think prayer, we all know. We can just move on. If the time is up, we can move on to the next.
Much obliged, Your Honor. It was a pleasure arguing before this bench.
You were brilliant, counsel. Very well done. Very good effort and effective assistance to the whole bench.
Thank you so much, Your Honor. It means a lot.
Hello. Am I audible?
Yes, yes, yes.
May it please this honorable court, the council seeks permission to address the bench collectively as your lordship.
Please proceed, counsel.
Please
Much obliged. The council seeks permission to present a speech.
Please proceed, counsel. You need not take our permission for each and everything. Please proceed. If you have any questions, we'll put it to you.
Much obliged, your lordship. Your lordship, the counsel on the side of the respondent in the case concerning Mr. Avan and others versus Union of Indus and others shall argue for the 20 minutes and shall deal with the issue 1, 2, 4, and 6 respectively. And my co-counsel shall argue for the 20 minutes and shall deal with the remaining issues. We respectfully reserve 5 minutes for rebuttal. If your lordship have no any preliminary inquiry, and if the lordship is well versed with the fact and the jurisdiction of the case, the counsel seeks permission to proceed with the merit of the argument.
Please do.
Much obliged, your lordship. Your lordship, we believe that the petition is not maintainable before this honorable court. Your lordship, the council would like to address the aforementioned issues into 3 limbs. Your lordship, coming to the first limb, which particularly talks that the petition filed by the petitioner under the Article 32 is not maintainable. Your lordship, the council would like to rely upon the 2 grounds, that is, the petition does not have a locus standi and the petition has an option to exhaust the alternative remedies. Your lordship, relying upon the case of Andhra Industrial World versus Chief Controller of Import, for a greater convenience, the court may refer to the para 1, page 7 of the compendium, Your Lordship.
Counsel,
where this order-
I think I will interrupt here, and I would like to inform you that the bench is not inclined too much on this preliminary objection, because the bench feels that in times of such national crisis, if Article 32 remedy cannot be made appear mere perfunctory remedy, it has to be an effective remedy that can be accessible. So I think you can quickly touch this issue and move on to the next one. We are not inclined to send this to High Court.
Much obliged, Your Lordship. Your Lordship, furthermore, we believe that the petition has not exhausted the alternative remedies. Your Lordship, this Honorable Court, in the case of P.N. Kumar versus Municipal Corporation of Delhi, this Honorable Court has clearly stated that the alternative existing remedy should be exhausted, which was not exhausted in this instant case. Furthermore, Your Lordship, we believe that the petition, the appeal, and the SLP is not maintainable before this Honorable Court, mainly on the ground of suspect.
Counsel, I think we should move on to the next point, because the alternate remedy is not going to take you any far, because alternate remedy always has to be understood in the facts and circumstances of a particular case. Like I explained to you, the bench feels that the issue of such national importance, if it has arisen for consideration of this court, then this court is not going to shirk from its responsibility in deciding the issues.
Much obliged, Your Lordship. Your Lordship, moving to the second submission on the side of the respondent, which clearly states that a non-perusal of the incomplete application does not amount to the order and determination, and hence it is not appealable. Your Lordship, for this, the Council would like to address the aforementioned issues into 3 limbs. Your Lordship, moving to the first limb, which particularly talks about the application was incomplete in nature. Your Lordship, in the case of Royal Medical College versus Union of India and others, Your Lordship, for the greater convenience, the court may refer to the written submission, the page 6, Your Lordship, where this Honorable Court has clearly stated that the incomplete applications amount to the initial ground for the rejections. Your Lordship, point to be noted here is that in
Counsel, you are again, I'm laboring on this point, but you are aware of the long heritage of this court, where even letters have been taken cognizance of, newspaper reports have been taken cognizance of. So I will request Counsel to not labor too much on the procedural aspects and come straight to the point.
Much obliged, Your Lordship. Furthermore, Your Lordship, the second submission, second limb talks about the purpose of the act. Your Lordship, the point to be noted here is that the Council is just trying to highlight the purpose of the Biological Diversity Act, Your Lordship. Relying upon the case of Sharat Babu versus Government of Delhi, Your Lordship, this Honorable Court has clearly stated that the IT Act is a special act and it should be given the special care, Your Lordship. Your Lordship, in the instant case, the Biological Diversity Act is also a special act and it should be given the special care. Your Lordship, the rule which was prescribed, the biological diversity rules, was in accordance with the Biological Act, and hence this act should be taken the special care, and the purpose of the act has been fulfilled by the NBA authority. Moving to the third limb of the second submission, which particularly talks that the NBA has acted in accordance with the procedure established by law. Your Lordship, for this, the Council would like to rely upon the case of Menka Gandhi versus Union of India. Your Lordship, in this particular case, the 3 grounds has been laid down by this Honorable Court that if the 3 grounds have been fulfilled, then it amounts to the procedure established by law. The first ground, the initial ground,
judgment also laid down the test of due process, Counsel. It is not just procedure; the process has to be due process.
Indeed, Your Lordship. The very case of the 1978 talks about the due process, Your Lordship. And the point to be noted here is that there has been the procedure established. The procedure has been followed by the NBA authority in consonance with the due process of your Lordship, due process of law, Your Lordship. Your Lordship, the first factor talks about the law must be followed the procedure. Your Lordship, the point to be noted that the Biological Diversity Act talks about the laws and the procedures was enshrined under the Biological Diversity rules, which was followed by the NBA authority. Second most, the procedure must satisfy the requirement of the Article 14. Your Lordship, for this, we have in separate issues, whether we have talked about that how this act satisfies the Article 14, and for must be just, fair, and reasonable. For this, Your Lordship, the Council would like to rely upon the case of Shankar Tiwari versus State of Bihar. For the greater convenience, the court may refer to the page 33, para 50 of the compilation, Your Lordship. where this honorable court
Council,
has
we are all
clearly
aware
stated.
about the tests of Article 14. We are fully aware about, you can take it that this bench is fully aware about the dual test of intelligible differentia, as also the requirement of the nexus between the objects sought to be achieved, and that. But please enlighten us. We would like you to be instructive about how in the facts of this case, the test of Article 14 is met. Please don't labor about the act. Please come to the specific facts as to how they are fulfilling the test, the dual test of Article 14.
Much obliged, Your Lordship. Your Lordship, as the Council has already stated that for this we have a separate issues, and which will be dealt by my co-counsel, if the Lordship allow that to answer this question to my co-counsel, Your Lordship. Much obliged. Your Lordship, hence it is humbly submitted before this honorable court that a non-perusal of the incomplete application does not amount to the order or determination and is available before this honorable court. Furthermore, Your Lordship, moving to the next submission of the written submission, which particularly talks that whether NBA is a state and whether the action of the NBA should be protected as a sovereign function or not. Your Lordship, the point to be noted here is that the section 8 of the Biological Diversity Act authorize the NBA to act in accordance with the act and on the behalf of the central government, relying upon the case of R.D. Shetty versus Airport Authority of India, Your Lordship. In this case, Your Lordship, the 5 factors has been illustrated that this honorable court has clearly stated that if these 5 factors has been fulfilled, then that particular body can be termed as a state. Your Lordship, the first factor is whether the body has been financed by the government or not. Your Lordship, indeed, the section 8 to section say the function of the national, the function of the NBA have been enshrined, has been talked about the biological.
Sorry to interrupt again, Council, but what is your submission that it does not fall in the definition of state?
It falls in the definition of state, Your Lordship.
Then it is amenable to writ jurisdiction.
It indeed not, Your Lordship.
How do you say that, Council? If you are admitting that it falls in the definition of state, then how do you say that it is not amenable to writ jurisdiction of this court?
Indeed, Your Lordship, for this, the Council is going to address the sovereign function where the act of the NBA has been protected, Your Lordship.
Please do.
Much obliged. Your Lordship, furthermore, the second factor talks about the deep and pervasive control. Your Lordship, the section 8 talks about that the central government has authorized the NBA authority, and hence there has been a deep and pervasive control of the body itself. Furthermore, whether the state enjoys a monopoly status or not. Whether
Council,
the body
Council, this you have already established. Go further.
Much obliged, Your Lordship.
Once it is established that it is state, what further?
Much obliged, Your Lordship. Your Lordship, moving to the second limb of the submission, which particularly talks whether the act of the NBA should be protected as a sovereign function or not. Case of agriculture product market Committee versus Ashok Harikundi. Your Lordship, in this particular case, the court has clearly stated that if the body has been performing the in an 11 functions, then the body can be termed as a state, and the actions of the body shall be protected as a sovereign function. Your Lordship, point to be noted here is that we have to understand the meaning of the sovereign function. Your Lordship, the sovereign functions is what that determines that for which the function for which the body is not answerable before this honorable court. Your Lordship, there are 3 primary functions, which are in order to protect the defense of the country, in order to deal with the arms and the denominations of the country, and in order to
one question, Council. This concept of sovereign and non-sovereign function, which was evolved long back with P&O navigation case, don't you think the whole concept has considerably changed, particularly after Nagaraj case? So this court would like to know your knowledge about the present status of sovereign, non-sovereign person, particularly when there is a case of violation of fundamental rights.
Much obliged, Your Lordship. The Council is just trying to establish that there has not been any violation of the fundamental rights, and with respect to the P&O navigation case, Your Lordship, the year 1869, Your Lordship, the case itself states about what will be the sovereign, what the act should be considered as a sovereign function and what act should not consider as a sovereign function. The point to be noted here, Your Lordship, if we compare the case of the N. Nagendra Rao versus state of Andhra Pradesh, Your Lordship, where there has been stated that in the modern era, the sovereign function, the importance of the sovereign function does not exist. But Your Lordship, the situation here is that the function of the NVA was acting in accordance to protect the peace of the country, Your Lordship. Your Lordship, for this, the council would like to deduce the some concept from the fact, Your Lordship. Your
No,
Lordship,
how? Council, 1 minute. Again, I interrupting you. How are you going to apply this law in your matter?
much obliged, Your Lordship. For this, the council is going to deduce the fact from the moot prop, Your Lordship. Your Lordship, the fact clearly state, the para 9 of the moot prop clearly state that the 54 people have died, and there has been the disturbance in the entire country with respect to the disease called the blood fire, which is going to be turned into the pandemic. For this, we have to understand, Your Lordship, that if the disease has been turned to the pandemic, then ultimately there has been the chaos in the country, and it will ultimately lead to the disturbance of the peace and harmony of the country, Your Lordship. And that is why we are saying that the NBA has acted in accordance with the procedure established by law, and the NBA action should be protected as a sovereign function, which is where the peace and the protection of the peace and protection of the harmony is one of the third factors for the in the case of the agriculture productivity, Your Lordship.
All right, move further.
Much obliged, Your Lordship. Furthermore, Your Lordship, we believe that the NBA being free to implement, NBA being an executive body, is free to implement and administer the law. Your Lordship, relying upon the case of N. Nagendra Rao versus state of Andhra Pradesh, Your Lordship, this Honorable Court has clearly stated that the legislature is free to legislate the law. Similarly, the executive is free to execute the law. Your Lordship, the point to be noted here is that the Biological Diversity Act has authorized the NBA, and NBA was acting in accordance with the biological diversity. Hence, it is humbly submitted before this Honorable Court that the NBA is a state, and its act should be protected as a sovereign function. If Your Lordship is well versed, the Council seeks permission to proceed with the next submission, Your Lordship.
Please move further.
Much obliged, Your Lordship. Furthermore, Your Lordship, we believe that NBA does not stand responsible for the harm caused to the endangered use, Your Lordship. Your Lordship, the point to be noted here is that we have to consider all the circumstances upon which the NBA has acted. Your Lordship, relying upon the case of Bihar Private Technical and Professional Association and others versus State of Bihar, Your Lordship, in this particular case, the court has clearly said that the health, safety, and the welfare of the public is supreme in law. Your Lordship, the point to be noted here is that the government has also taken the considerations of the health, which was very much essential for the entire country, Your Lordship. It's not about the particular tribes. It's not about a particular person, that is a Ramesh or
just 1 minute. Again, I'm stopping you. Council working under some special circumstances like pandemic and all. Is it give a license to the authority to work like concealing the facts, making fraud agreements, concealing material facts, and getting the thing done at the cost of tribes and all, even violating of the fundamental rights of the tribes, which is well prescribed under the Constitution of India? Is it give the such license, or what you want to convey?
Indeed, Your Lordship,
particularly about the circumstances just established.
Can the Lordship repeat the question?
You said that in particular circumstances, board is acting, right? So my question is whether a particular circumstances like pandemic or any other emergency situation give an authority to the or give a license to the board to have to undertake agreements with the tribes, that is with concealing the facts and avoiding so many required conditions and circumstances and even violating fundamental rights.
Much obliged, Your Lordship. For this, the Council would like to deal the question into two folds. Your Lordship, moving to the first fold, which particularly talks about the laws of the law existing in the country, Your Lordship. For this, the Council would like to rely upon the case of Subramaniam Chaubey versus Union of India. In this particular case, this Honorable Court has clearly stated that if there has been a conflict between the two fundamental rights, particularly the one of the fundamental rights is the Article 21, then if the situation arises that who will pertain over the other, then the Article 21 should be pertain over the other by considering the fact that it talks about the right to life of the Constitution, right to life of the citizens and the non-citizens as well, Your Lordship. And furthermore, if we moving to the second poll, which talks about the fact, Your Lordship, the point to be noted here is that the BDB has contracted with the NBA authority, and the BDB has agreed that yes, you take the plant and you can approve the plant in accordance in order to make the medicine. Although the fact is silent about the amount of the plant that should be uprooted. But Your Lordship, the point to be noted here is that the BDB has agreed with this terms and condition in order to approve the plant, Your Lordship. If this satisfies, may the council proceed.
Okay, move forward.
Much obliged, Your Lordship. Furthermore, Your Lordship, we believe that the state, the NBA is immune under the section 54 of the Biological Diversity Act, Your Lordship. Your Lordship, the section 54 of the Biological Diversity particularly talks about the protections of the act of the NBA, act of the authority the act which is in order with the protection of the public interest. Your Lordship, the point to be noted here is that it also talks about the concept of the good faith, which has been illustrated in a different act, and it's provide an immunity for the act which was taken in consideration by considering the public interest, Your Lordship. Hence, Your Lordship, there has been no such violation, and the harm caused to the endangered species, the NBA should not be held liable. If this satisfies, the council seeks permission.
One question. You are pleading everything on public interest here, but there are two public interests. Public interest, your public interest, as well as public interest of the tribe. So how do you decide that this interest will prevail? This court would like to know.
Much obliged, Your Lordship. The council would like to highlight the case of Subramanian Swamy versus Union of India, where the court has clearly stated about the importance of the right to life, Your Lordship. Here, the court should also consider that the life of the tribe has also been threatened. If there might be the situation that a disease might affect the tribe as well, Your Lordship. So we have to consider as well, and the government should not consider about the particular tribes. The government should consider about the entire nation, Your Lordship. I hope this satisfies.
Okay, move forward.
Much obliged, Your Lordship.
Yeah, Council, I just had a query. So in your view, see, the Biological Diversity Act is of the year 2002. So now if let's take it for a moment that you just cited a few sections from this act. So if there is a, let's say, conflict between the provisions of this act and the subsequent act, which is the Recognition of Forest Rights Act 2006, which lays down certain inalienable rights for tribals, which act will prevail?
Much obliged, Your Lordship. Here the concept of harmonious construction will arise, Your Lordship, and the state and the government will try to harmonize. Is that we have to consider the situation. Again, the council is trying to highlight the situation. It's not a normal situation. The disease is going to be turned into the pandemic if it's not been carved out, particularly with respect if the medicine has not been found, Your Lordship. Then
no, but then when you talk about harmonization, what are the safeguards you have put in place to ensure that there will be no outright obliteration of the rights ensured under the Forest Dwellers Act? What are the steps you have taken?
Indeed, Your Lordship, the council is unaware of this. If this satisfies, the council would like to call upon the second speaker.
Yeah, so my query was, when you say harmonize, what does this harmonization mean? Does it mean finding a balance, or does it mean that one act in the appropriate circumstance will completely override the provisions of the other? So what do you intend when you say harmonize?
Indeed, not, Your Lordship. It doesn't mean that one act will overlap the other act. It simply means that there should be the balance between, if the conflict arises, it's a function of the states, or it's a function of the legislature to harmonize both the act in order to take the balance, in order to maintain the balance.
So what is the balance? That's precisely the question. What is the balance which you are identifying in the facts of the present case? What is that balance?
Your Lordship, the balance which we are just portraying about the right to life, Your Lordship, here. We are just trying to state that, Your Lordship.
Okay, thank you.
Much obliged. It was pleasure to argue before this. Thank you.
Hello, Your Lordship, am I audible and visible to you?
Yes, please.
Yeah. Before coming to the argument, I would just like to contain that there are certain network glitches in our side, in my side. So if there is any issue, please kindly inform Your Lordship. May the council proceed, Your Lordship.
Yes, please.
Much obliged. Greetings of the day, Your Lordship. May it please this honorable court. This is the co-counsel representing respondent in the case of Mr. Aman and others versus Union of Indus and others. Your Lordship, I shall argue for 20 minutes and shall consider third, fifth, and seventh issue respectively. Your Lordship, coming to the third issue, which is related to the constitutional validity of Rule 14. Before submitting the argument, firstly, I would like to answer to the one of the question which has been put forward to my co-counsel related to this issue, and that question is that how it passes the test of Article 14, how this Rule 14 clause 2 passes the test of Article 14, Your Lordship. Your Lordship, for that I would like to rely upon the case of R.C. Paudyal versus Union of India, the very case of 1994, where the 5-judge bench of this Honorable Supreme Court, after relying upon the case of State of Madhya Pradesh versus Bhopal Sugar Industry Limited, in para 130 of the judgment, held that the legislature has always the power to make a special law, and in order to attain the objective of certain law, for the purpose of the authority to classify or select person, object, or transaction upon which the law is intended to operate. Your Lordship, for authority, you may refer to the page 49, para 77 of the compendium provided to you. Your Lordship, how this case is relevant in the stand case, Your Lordship? Your Lordship, we have to consider that Article 14, Clause 2 has a rational nexus between the objects sought to be achieved, Your Lordship. Your Lordship, we clearly know that there are 3 objects which this act, that is the Biological Diversity Act 2002, intends to operate. First is the benefit sharing. Secondly is the conservation of biological diversity, and thirdly is the equitable access and equitable benefit sharing, Your Lordship. In this stand case, Your Lordship, in order to fulfill all these conditions, we have to consider that there are certain regulations which needs to be regulated, which needs to be mentioned. Like in the stand case, Your Lordship, the amount fee, that is the application money of 10,000 rupees, has been imposed in the form of regulation, Your Lordship, and there is difference between the regulation and restriction, Your Lordship. As we know that in order to attain the objective of any act, it is very much competent, the legislation is very much competent to give certain regulation, Your Lordship. Your Lordship, how this particularly regulation, that is a 10,000 rupees in the stand case, has a rational nexus, Your Lordship, because, Your Lordship, we have to consider that.
If I can interrupt you for a second here and just pose my question, you specifically said that there is a difference between regulation and restriction. But there are situations and circumstances where a regulation itself becomes restrictive, and that is essentially the contention of of the other side, which is pinpointedly what you have to meet.
Much obliged, Your Lordship. Thank you for your question, Your Lordship. May I proceed with the answer? Hello, am I audible?
Yes, please go on.
Hello. Yeah. Much obliged, Your Lordship. Thank you for your question. Your Lordship, I would like to answer this question in 2 parts. Coming to the first part of the answer, even there may be certain situation we arise where regulation may become restriction, Your Lordship. But then also, Your Lordship, we have to consider that restriction can be imposed. And Your Lordship, whether any restriction can be imposed on a fundamental right or not, we have to consider that whether it is reasonable or not. Because as we know that Article 14, even Article 14, Article 14 as well as other fundamental rights are not absolute in nature, and certain restriction can be imposed, Your Lordship. And furthermore, Your Lordship, by citing the observation of this of the Chief Justice Patanjali Sastry, where in several cases the Chief Justice Patanjali Sastry has categorically held that that the Article 14 of the Constitution does not require that classification brought about by legislature be scientifically perfect or logically complete. What was intended in those cases, that there must be intelligible differencia. Your Lordship, as I have contended that in the instant case, although we consider for the instant case that in there may arise the situation of the restriction, but then also, Your Lordship, this restriction has a rational nexus with the object, Your Lordship, and Your Lordship, if there has a rational nexus, then of course it classifies the intelligible differentia test, Your Lordship, and that is sufficient to render the
Please, I request you that you should try and focus on the factual aspect of it. Please don't give us legal principles of how it meets the intelligible differentia and the ratio. Please tell us what is the exact nexus of prescribing a fee so high for the purpose of non-commercial investigation or use under the
Much obliged, Your Lordship. Thank you for your question. I would like to answer this question in two part, Your Lordship. Your Lordship, as we know that this restriction is not for the all the resources, or it is only for the one which is going to extinct or endangered species. In the stand case, Your Lordship, we have to consider that the species, that is a jamage plant, is endangered species, and if there is no regulation or restriction has been made, then it will become extinct. So in order to comply with the international obligation, this particular act in the form of Biological Diversity Act has came. Furthermore, Your Lordship, as contended by the petitioner, that the fee charged under Rule 14 Clause 2 is a sum of 10,000 rupees, which is unreasonable and arbitrary. But it is not so, because it is a mere regulation, Your Lordship. Furthermore, it is contended that the fee charged by National Biodiversity Authority under Rule 14.
Okay, Council, let's try and test your argument here. You are trying to say that this fee is prescribed for extinct or difficult biodiversity areas. So you think that prescribing this fee will allow will curb indiscriminate use?
Pardon, Lordship, can you please repeat the last?
Do you think that applying a fee will curb the indiscriminate use of such endangered species of the biodiversity?
Indeed, Your Lordship. Your Lordship, how this will going to curb the misuse?
If the commercial bodies or the commercial interests take over, if somebody with deep pockets wants to exploit this, if money is going to be the only consideration, there will be many corporations who will be in a position to pay multiple amounts of this fee and completely exploit the endangered biodiversity.
Much obliged, Your Lordship. Thank you for your question, Your Lordship. Your Lordship, this is not only the criteria, Your Lordship. Point to be noted why I am continuously relying upon this particularly Rule 14 Clause 2, because the petitioner has challenged, and in the moot proposition it is clearly mentioned about Rule 14.2. There are certain other mechanisms. Your Lordship, for instance, if the application is complete, then this application goes to the NBA authority under Rule 14.3. It is clearly mentioned that if the NBA authority is satisfied that this is for the public interest, and of course it is not going to endanger and it will not be misused, then only that person will be allowed to do research, Your Lordship and Lordship. So, Your Lordship, in the stand case, what we are trying to contend that each and every rule has a certain rational nexus between the objects sought to be achieved, Your Lordship. If that satisfied your answer, may the Council proceed.
You need not worry, Council, about satisfying us. You can answer in the best way that you can, and please proceed.
Mr. Council, I have a question.
Indeed, Your Lordship. Furthermore, Your Lordship, Indeed, Your Lordship.
So when you refer to Rule 14.3 and you say that safeguards are there, then why you need such a high fee?
Indeed, Your Lordship. Thank you for your question, Your Lordship. Your Lordship, as we note that one of the most important particularly object of this act is the assets and benefits sharing, Your Lordship. So, Your Lordship, this particularly fund is utilized for the welfare of the public, as mentioned in the section 27 of the act itself, Your Lordship. Section 27 of the act, it is clearly mentioned that the fund which will created from the application money will goes in certain things. Firstly, that mentioned in channelizing the benefit to the benefit claimer. Secondly, conservation and promotion of biological resources and development of areas where such biological resources or knowledge associated thereon has been assessed. Thirdly, socio-economic development of areas referred in clause B in consultation with the local bodies concerned, Your Lordship. So, Your Lordship, this fee is very needful in order to achieve all these objectives, Your Lordship. So that is why the reason the amount that is a 10,000 rupees has been mentioned, Your Lordship. And furthermore, Your Lordship, we have to consider the very purpose when we talk about any fee is arbitrary or not, or even we have to consider that this particularly plant, which is the jamage plant, is not the plant which is like a normal plant. Rather, it is a plant which is of the medicinal use, and it has got certain. Hello, Your Lordship. Is
Yes, we're listening to you. Please continue.
Yeah, can I switch off on my video? Switch off my video because I think my speaker is
So
telling
we
that.
can hear you and see you clearly. Please
Okay,
proceed.
indeed, Your Lordship. So, Your Lordship, in this stand case, Your Lordship, because of all these objective concerning its totality of the case, we have to consider that this particular Rule 14 Clause 2 specifically, which has been challenged by the petitioner, has a rational nexus and is not arbitrary. Because, Your Lordship, we have to consider that mere hardship which has been caused to someone, like in this stand case, although we agree that certain hardship has been caused to Mr. Aman, but Your Lordship, I would like to rely upon the case of Andhra Pradesh Cooperative Oil Seed Limited, Federation Limited versus D. Advaita Char, the very case of 2017, where the Honorable Supreme Court itself felt that the restriction imposed was not unreasonable, as mere fact that some hardship has been caused to someone is no ground to obstruct on any legislation unconstitutional in nature. How this case is applicable in this?
This is not a case of mere hardship. You have to appreciate that this is a case of probably irreparable injury. What your actions are leading to is complete extinction and complete irreparable damage, which cannot be set right by any further judicial intervention.
Much obliged, Your Lordship. Thank you for your question, Your Lordship. I would like to answer this question in two parts. Your Lordship, how, although we agree that there certain injury has been happened and it may be irreparable in nature, Your Lordship, but Your Lordship, we have to consider that there is a principle that talks about necessity knows no law. Your Lordship, in this stand case, we have to look upon the circumstances, fact and circumstances that is prevailing in this state, Your Lordship. As we know that blood fire is a disease and it does not have any cure. So in order to develop the medicine, in order to save the life of the person, it is necessary and it is the need of the hour to particularly go and research and of course create the medicine with the help of Jamesh plant. Furthermore, Your Lordship, although we agree that there has been certain things which has been not mentioned in the fact sheet, that up to what extent the Jamesh plant will be uprooted, but Your Lordship, the one thing is very much clear that whatever the uprooting has been done with certain objective to achieve, and that is the need of the hour. Furthermore, coming to the second fold of the argument, that in the stand case, Your Lordship, there are two applications which came to the NVA authority, and the NVA authority has acted in the procedure established by law and has allowed the Tiscola, who has done research and creates the vaccine, which shows that whatever the NVA authority has done in this stand case has done as per the need of the hour, as the necessity of the hour, and further in public interest, Your Lordship. If that satisfied your question, may the council proceed.
I have one question. You were just talking about the development of the area with the fees so collected. You are trying to make a rationale of the fees so collected. But in that, for the development of area, you are already going for the benefit sharing agreements. One thing. So why this small fees is to be considered for that? And he has given two applications. One application to waive the fees under certain circumstances. This is emergency situation, and you yourself is accepting that the good research is required for that, and somebody should come up with the vaccine and all. So why the other application has not been taken into consideration?
Much obliged, Your Lordship. Thank you for your question. I would like to answer this question in two parts. Your Lordship, coming to the first part of the answer, that the Aman has been stopped from doing the research because the application was incomplete, and of course the state wants that research must be done good. And Your Lordship, as we know that this particular species is not the normal species, Your Lordship. So we cannot allow one person and looking upon which the scenario, Your Lordship, that of course there are two applications came and application came, and the NBA authority think fits after considering the application fee, and after that, according to the Rule 14.3, which talks about the hearing the party and after satisfying all the requirements, the NBA came to conclusion that it is for the public interest and for creating medicine. Furthermore, also there must be provision, there must be certain restriction to approve the Jamesh plant, because we have to consider that we cannot allow each and every person to do on that species, because it is very limited in nature, since it has declared endangered species by the IUCN itself.
According to you, where is the public interest in allowing a person who is good in research to go for the research, or following such procedure which was established long back and has got no rationale behind it? Where is the public interest lies?
Much obliged, Lordship. Lordship, in the stand case, what the contract contained that public interest here is that in the stand case, Your Lordship, the whole and sole purpose of the research is to create the medicine, Your Lordship. So, Your Lordship, in the stand case, Your Lordship, the public interest which involved in the stand case is that the very purpose of the research which has been allowed by the NBA to the Tiscola is to allow to create the medicine which is the need of the hour, and which is in order to protect the right to health of the people who has been diagnosed by this particular disease, that is the blood fire, Lordship. So in this stand case, here the public interest lies, Your Lordship.
Your action, you have denied this person to go for the research, and you have constituted a committee, and which goes there in the tribe area and making fraud agreements, concealing the facts. So what is this? You are shifting. You just want to take over the whole thing and not to allow any honest person for any serious person for go for the research. What do you think about this?
Much obliged, Lordship. Lordship, thank you for your question. I would like to answer this question in two parts. Coming to the first part, although the government has formed the committee and has further proved that the research of Aman is good, and of course it has certain rational nexus with the medicine. Furthermore, in para 24, it is clearly mentioned that after the committee has been formed and the committee has submitted their report, it is clearly mentioned that they have gone to Mr. Aman in order to inform that the dispatch of such a committee has gone and assured him that if his claim holds true, then that would be a stakeholder in the consequent benefit. We saw that there was no malicious intent from the side of the NBA. Furthermore, coming to a second fold of the answer about the concealment of fact in the stand case, Your Lordship. Your Lordship, in the stand case, as we know that the contract has been signed under section 21 of the Act, which talks about the equitable and fair benefit sharing. Your Lordship, although in para 26 it is clearly mentioned that although the non-commercialization means the medicine has not been yet commercialized, but then also, Your Lordship, in para 27 it is clearly mentioned that after 30 days the BDB has got the proposal from the NBA about the benefit sharing, which shows that there has been no concealment of the fact from the side of the NBA authority, and the NBA authority has acted as per the
contract.
Council, I have a point to make here and a question to ask. This is a question that we have to ask not just to ourselves as a, as to you as councils representing this side, but this is a question that I think our entire generation needs to ask ourselves. When it comes to natural resources and, natural resources which we have inherited from thousands of years, these resources are not resources which we hold as owners or in a position of authority. This court has held in multiple judgments that we are trustees of those natural resources, and we hold them really as a debt towards future generations. So why do you think that this court should allow indiscriminate use of such a scarce natural resource that our future generations would be completely deprived from having any benefit or any existence of that natural resource?
Much obliged, Your Lordship. Thank you for your question. I would like to answer this question in two parts. We agree with Your Lordship contention that we are the trustee of the natural resources, Your Lordship, and we have to do the sustainable development as well. But Your Lordship, we have to consider that whatever the state that the Indus has acted accordingly, according to the convention which has been ratified by our country, that is the Indus, that is a Nagoya Protocol, and in order to maintain it in the domestic law, the Biological Diversity Act 2002 came into existence, Your Lordship. So, Your Lordship, furthermore, there are certain objectives like the conservation of biological diversity. The state has acted, and furthermore, one more convention, that is the CBD, conservation of biological diversity, and accordingly the government has came with the act, Your Lordship, that is the Biological Diversity Act. Furthermore, it shows that the government is very much aware about the natural resources and is conscious. Furthermore, Your Lordship, as we know that there are certain circumstances which may arise, which is not in our hand, like this pandemic, Your Lordship. In this pandemic, Your Lordship, we have to consider that we have to respect the national biodiversity resources as well as environment. Lordship, in order to protect the right to life of the person, which is the basic human right, which cannot even be violated at the time of emergency, in order to protect the right to life, as we know that this particular disease is directly threatening the right to life of the person, Your Lordship. So, Your Lordship, in order to curb the diseases and in order to protect the right to life, the government has taken this decision and has done excessive uprooting of the plant in order to make the medicine and in order to curb the disease. Because if it has not been curbed now, then of course it will definitely going to threaten the whole sovereignty of the country, and the law system will be going to be corrupted, Your Lordship. If that answer to your question, may the council proceed?
Please go on, council, if you have any other submissions to make.
Indeed, Your Lordship.
The time that is available.
Indeed, Your Lordship. Your Lordship, coming to the last submission that is related to the Epidemic Disease Act, the council would like to submit that Epidemic Disease Act is constitutional in nature under twofold. Coming towards the first fold, that how it is in consonance with Article 14, Your Lordship. Your Lordship, in this particularly for that I would like to rely upon the case of D. Fruitias versus Permanent Secretary of Ministry of Agriculture, Fisheries and Housing. That is the very case of 1999, where the Honorable Court held that the principle of proportionality has to be seen. Your Lordship, the council seeks permission for the extension of time in order to complete this
issue. Council, you
and
need not labor on this because we need not have any exposition on the point of constitutional validity of the act. You've exceeded your time. You may please sum up in 30 seconds.
Indeed, Your Lordship. So, Your Lordship, in the stand case, since the delegation has been given, but this act is for the exceptional circumstances. So, mere hardship cost to that is the case which I have already referred the AP Corporation case. Mere hardship cost to someone is not a ground to obstruct on any act unconstitutional. How it applies in the stand case? Because Your Lordship, Epidemic Disease Act cannot be struck down because of the act of the one police official, and even it had not been proved yet, it is mere allegation. So, this act is constitutionally valid. Coming to the, if Your Lordship satisfied, the council would like to submit prayer.
Thank you. There's no need for the prayer, council. Thank you very much for your valuable assistance, yours and your colleagues' valuable assistance to the bench.
Much obliged, Lordship. It was a pleasure to argue before this honorable court.
With due permission, Your Honours, we shall now proceed with the rebuttals. Your Honours, the petitioners would request the learned opposite counsel to substantiate on these points. Firstly, the respondents need to clarify the difference between a self-imposed rule and a matter of right under the Constitution, referring to Article 226 and 32 of the Constitution. Your Honours, the right to move to the Supreme Court is a guaranteed fundamental right, and if a person chooses to invoke Article 32...
Counsel, you need not labor on this aspect. Please proceed to... the rebuttal is a short time. Please come to the crux.
Indeed, Your Honour. The second point being, the respondents have relied on cases like Royal Medical Trust and Dental Council of India to establish that incomplete applications cannot be processed. The respondents are expected to show that whether these judgments arise out of the BDA and whether the NBA has such powers.
You would have seen that even this we are not convinced on the respondents, so please don't labor on that. Wherever we are with you, please don't labor on that. Please highlight again on the aspect of restriction versus regulation, and why are you contending that?
Indeed, Your Honour. The respondents have further identified the concept of intelligible differentia. However, they have failed to establish the existence of the same, as it is clear when the application is for non-commercial research, intelligible differentia doesn't exist. Moreover, Your Honour, they say that the amount of 10K is reasonable. How is it reasonable when a person only needs it for non-commercial purposes and in a very small amount? The next point would be the respondents have very well submitted as to the presumption of validity of law. However, the case in point that requires addressal is only a rule under the said law and not the entire law. They are expected to show how the said rule is valid even when the purpose for accessing the resources for non-commercial purposes. Lastly, the respondent themselves...
This has already been discussed, and my bro judge has already asked you that whether he has applied for the, and has he given any application that it will be used for non-commercial purpose.
Indeed,
so repeating it again and again, it has got no meaning.
The council would just reiterate that the respondents have submitted that the NBA is indeed a state, Your Honours, and hence it cannot be sued for the violation of any of the fundamental rights, and hence it can be sued for the violation of fundamental rights under Part 3 of the Constitution. How do the respondents justify that every decision or action of the state will amount to sovereign function and hence can be protected? It goes beyond the scope of Article 12 of the Constitution if they are allowed to do so. It is also expected of them to show that how in a post-constitutional law era, the said rule is applicable, since post-independence, the courts have constitutionally narrowed down the ambit of
this
sovereign
court
functions.
Is not going to bind itself into these principles because these have been liberalized in the post-constitutional era. But the point really is that how does the application of a fee makes the whole process restrictive and not really regulatory?
Your Honor, the respondents have failed to answer the same, and the further rebuttals will be handed by my co-counsel.
Sure.
The respondents need to clarify in the following stances. One being, the respondents submitted that all facts were disclosed by them before entering into the contract. However, they did not disclose that they have immunity such as protection against any action taken by them that affects the rights of citizens. Such exceptional powers were not intimated. Can the same be furnished from facts? Additionally, the petitioners admitted that BDB comprises of educated members, but they are only capable of understanding a law as read to them. How can they be expected to interpret beyond scope of knowledge? Second point being, Your Honors, that the respondents state that Bholias are not a tribe. However, they may refer to para 19 of Moot proposition, wherein it very well begins with the statement that Bholia tribe is an indigenous tribe in the foothills of Himalayas who are very well protected by virtue of Schedule 5, read with Article 341 of the Constitution. The respondents need to show this in fact and in law. Third point being, the respondents have relied on certain tests to check the validity of a legislation. It is expected out of them to show in light how the Epidemic Diseases Act sustains in a post-constitutional era where rule of law exists and constitutional supremacy is engulfed. Where does the Act uphold these rights by one, providing exemptions for essential services such as food, which was recognized as a fundamental right in PUCL versus the Union of India, healthcare, and other alien necessities. And second, where does it show that
Counsel, you mean to say that these rights which have been recognized as fundamental rights under Article 21 can trump the very right to life itself? We are talking about mutually competing fundamental rights here. It is not like one fundamental right, trumping another fundamental right. You think all of these can trump the right to life itself?
Your Honors, for a wholesome availability of Article 21 to the citizens, in the case of PUCL versus Union of India, the ambit of Article 21 itself was extended to right to life, to right to food as being part of a fundamental right and being inclusive in under Article 21 itself. Your Honor, moving on, where does it show in the Act that there is uniformity with central government prescribed by way of Disaster Management Act as it extensively relies on executive?
How can there be uniformity? Again, this is a situation which is very dynamic, which is different in different states, different parts of the country. That kind of leeway and play in the joint has to be allowed. Also, you have not answered this aspect that can right to life be trumped by other rights. If there are two competing rights on both sides, they are both fundamental rights, then how the balance has to be drawn?
Your Honor, answering to the first part of the question, if the different district level bodies itself are given their own interpretation of good faith, now any district can get saved by arresting, beating, or abusing the people who step out, and then claiming that they acted in good faith. Your Honor, answering to the second part of the question, Article 21's ambit also includes the right to life ambit also includes right to food to provide the citizens a wholesome right under Article 21 itself, Your Honor. Therefore, a person cannot just sustain if he is protected from the pandemic, but he also needs to be given the right to secure to himself the essential services as well, Your Honors. Your Honor, moving on. The fourth submission is that the progressive society can't subdue SC/ST or minority communities since the constitutional supremacy secures to the tribe basic livelihood. The patients will recover in a few days or weeks, but what about the livelihood of the tribe after the extension of the plan? Can the respondents ensure a roadmap for sustainability of their livelihood? That was all, Your Honors. It was a pleasure arguing before this bench.
Thank you, counsels, for your assistance.
Hello. Hello.
Yeah.
Hello.
Am I audible?
Please proceed.
Indeed. Your Lordship, the counsel would like to state that how the facts have been quite easily been molded by the petitioner, that they are saying that the NBA does not have the intent. For this, the counsel would like to rely upon the para 27, which talks about the intent of the NBA authority. They have also talks about the commercial purpose, that someone was acting in non-commercial purpose. For this, the counsel would like to rely upon the para 12, where the Aman has quit the job in order to do the research. Furthermore, Your Lordship, they have also talked about that the NBA doesn't consulted with the local authority. For this, the counsel would like to rely upon the para 25 of the Moot problem, where it has been clearly stated that the NBA has concerned with the local authority, and accordingly they have signed the contract with the NBA authorities, with the Bholia Development Board. And now I would like to call upon the second speaker to carry on the next rebuttal.
Yeah. Hello, am I audible?
Yes, please go ahead.
Yeah. Coming towards the third reverter related to the Epidemic Disease Act, the two questions have been put forward by the respondent. One is related to the rule of law, how it is in consonance with rule of law. Your lordship, in this stand case, we agree with the fact that certain delegation has been given to the state official, because your lordship, this act deals with the extraordinary situation. But your lordship, there has been certain regulation which has been made, which has been clearly mentioned in section 4. Your lordship, in section 4, there is a term which has been made that if any action of the government which is in good faith can only be protected under this act, which has also been upheld by the court in the case of Ram Lal Mistry versus Arctic Green, which is the case of 1904, where the Privy Council has upheld this. Furthermore, your lordship, in this stand case, I have clearly intended that even there has been allegation which has been made by Mr. Ramesh in this stand case that there has been brutal torture happened with him. But that again, I would like to rely upon the case of AP Corporation, that case of 2007, where the Honorable Supreme Court clearly stated that mere hardship caused to someone is not a sufficient ground to declare any legislation unconstitutional in nature. For that, the council from the side of the petitioner have to prove that how it gives the excessive delegation. In this stat case, since the word good faith has been used under section 4, which clearly shows that each and every action of the state government or state official cannot be protected under this act, which shows that there has been check and balance and is accordance with rule of law. Coming to the second, that is related to that always continuously put forward by the lordship and the opponent, that the related to the regulation and restriction. Lordship, your lordship, the only intent when this particularly 10,000 rupees has been imposed was to merely regulate the excessive use of the species which is related to the biological diversity. Although there may be situation which may be created that regulation becomes the restriction, but then also, lordship, in that scenario, what is the duty of the court? The duty of the court is to see that whether there exists a additional nexus between the objects sought to be achieved, and I have already proved that there is certain object which this species of biological diversity act tries to achieve, and in order and because of that, this particular rule 14.2 has been framed. Furthermore, coming to the next rebuttal, that they have told that there does not exist the intelligible.
Counsel, you seem to be reminding the court of the obligation that it holds. This court is extremely conscious and cognizant of the obligation that the Constitution imposes on it. But equally, you seem to be shirking from your own responsibility and your own duty that has been imparted on you. You are merely relying on adversity and hardship. You have not addressed the aspect of irreparable damage and injury to a very, very scarce biodiversity resource.
Much obliged, Your Lordship. Thank you for your question. Your Lordship, in this stand case, I have clearly contending that whatever the action of the NBA has happened in this stand case is according to the need of the hour. However, we agree with the point that there has been certain irreparable loss which happened to the Jamaiz plant, but that also has certain rationale with the object, Your Lordship, and that object is to protect the fundamental right, that is the right to life, that has been violated by the blood fire disease, Lordship. As we are clearly, one thing is very much clear, that there does not have any existence remedy for the curing the blood fire disease. So in order to curb that disease, in order to maintain the right to life of the person, there has been irreparable loss caused by the NBA, and which is also in the public interest. For a state, the public interest always matters, Lordship, and the
Counsel, again, the same point that I've made to your colleagues on the other side, that it is not a question of one public interest alone. This is a case where there is a question of two competing very strong public interests. What is expected from a constitutional organ of the executive is to draw a fine line, to draw a balance, to walk the tightrope. I mentioned in the beginning, this is not a choices like an apple and an orange. These are Hobson's choices. And in such difficult choices, it's the balance that the constitutional organ of executive draws that really determines whether its actions can be sustained under the Constitution or not.
Your Lordship, before answering this question, I would like to extension of time because time is over.
Counsel, I think your time is up.
Time is up.
Hello.
Kindly just sum up in 30 seconds.
Your Lordship, in this stand case, I would like to rely upon the Subramanian versus India, where Honorable Supreme Court clearly stated that whenever there is conflict between the two derived rights, then one which is in larger public interest should prevail. In case, Lord, is why the larger public interest, that is the need of the hour, that is the cure blood for disease, will prevail in the circumstances. That is only contention that the respondent would like to contain. With this, the counsel rest is rebuttal. It was pleasure to argue before this Honorable Court.
Thank you.
Thank you.
Thank you, everyone. Thank you, ladies and gentlemen.